Thank you very much, Sarah, for the introduction and for to the organisers for inviting me. So I hope that my paper today will follow on in some ways from some of the discussion this morning and maybe raise a question about the dangers of relying on the law to save us or to protect us. So, as Sarah said, I'm going to be focusing on Britain, and I'm going to be zoning in on some recent practices of the police and the Crown Prosecution Services in Britain in dealing with recent protests. But what I'm going to try to do is to draw some historical connections between the offences that are used today and kind of look at how they developed over time. So my paper will try to draw a genealogical link between the common law offence of unlawful assembly, which took shape following the Peterloo Massacre in Britain of 1819, and its statutory successor, the offence of violent disorder. And this is the offence that is used heavily today by the police and the Crown Prosecution Service against protesters. And I'll be looking in particular at the case of the student protesters who were arrested in the course of the 2010 anti-fees protests when the government raised the tuition fees to £9,000 a year. This sparked mass student protests across the country. And there was a particular demonstration that ended with an occupation of Millbank, which is the Conservative Party headquarters in London. And what the paper tries to do is to demonstrate the depoliticizing effect of public order legislation and the effect this has of allowing political protest, a democratic political exercise, to become understood as a violation of community and anti-democratic activity. And then I'll try to end with a few words on how the offence of violent disorder is being used against protesters in a post-Brexit Britain vote context, which has its own particular challenges. So, to begin with, a few words on the criminal law and its relationship to protest. Although often phrased in terms of moral limits, the criminal law is understood here as state coercion. It's fundamentally a question of politics. The criminal law serves to stabilize a social order which is politically contested by depoliticizing it. It labels politically undesirable activity crime, thereby expelling that activity from the field of politics and relegating it to the sphere of morality and individual responsibility. The government and other state institutions, desirous to maintain the status quo, resort to the powerful ideology of criminal justice as a means of depoliticizing resistance, presenting it in terms of individual wrongdoing and disorder rather than as political contestation. What I will argue here is that we should not merely be concerned with what is technically an offence under the criminal law, but also with surrounding state practices, violent state practices, which contribute to the criminalisation of dissent, but which are habitually deemed to lack evidential value. The scope of the freedom to protest depends not only on the way in which its limits are legislated. So, for instance, in Britain, the relevant legislation is the 1986 Public Order Act, which has had the effect of depoliticizing protest through its creation of serious and flexible offences such as violent disorder, which has been used to capture those who engage in unwanted political activity, but also on the manner in which protesting is policed. Police tactics such as baton use, horse charges, the use of undercover officers and agents provocateurs all contribute to the criminalisation of protest. So I'll now look at the criminalisation of protest through history by starting with the origins of the common law offence of unlawful assembly. The British state, of course, has a long history of attempting to control what can be said and done by way of political protest. Until the late 18th century and early 19th century, its method of limiting free speech, in particular that against the state or church, entailed prosecutions under libel law. By the late 18th century, it was becoming increasingly unacceptable to limit what could be said in the form of political dissent. And yet the state was keen to find a way of retaining its hold on power in the face of radical oppositional activity, particularly the sort which manifested itself in the congregation of large crowds of people at rallies or in marches, which caused great apprehension to the local authorities. Prosecutions for expressions of political opinion were becoming increasingly difficult, but in this time of political upheaval, the state had to think of what else it could do to control what was being said against it. The content of what people published and what they said in public meetings and rallies frequently fell outside the scope of these libel laws, but nevertheless, they were regarded as being a threat to the way in which power was apportioned within society. And it was the Peterloo Massacre of the 16th of August 1819, which is depicted in this painting from the time by Richard Carlyle, which I'll come back to, and in particular the trials which followed, which paved the way for the use of public order offences against protesters, which are still used to this day. So despite the fact that the Peterloo Massacre is now widely regarded as one of the most abhorrent domestic stains in the history of the British state, and it's important to underline here domestic, considering the endless list of atrocities committed by Britain in the days of slavery, empire, and in the course of recent military intervention. Today's law continues to reflect in its content and operation the legal legacies of the trials which followed the massacre. So, the Peterloo Massacre began with a meeting at St. Peter's Fields, which is just outside Manchester, in 1819. There were about 60,000 or so people gathered, and they'd come to listen to the renowned orator and reformer, Henry Hunt. He was going to address the meeting on the subject of parliamentary reform and the extension of suffrage to all men, not women at this stage. Despite the entirely peaceful demeanor of the meeting, the Riot Act of 1714 was read, and the participants were forcibly dispersed by military officers on horseback wielding sabers. Once the Riot Act was read, the effect was that, I quote, justices and their servants engaged in efforts to disperse, seize, or apprehend rioters were to be free, discharged, and indemnified for the killing, maiming, or hurting of such person or persons who resisted. So essentially, those who killed and maimed in order to disperse those large crowds were allowed to do so. In total, 11 people were killed at Peterloo, and in excess of 500 were injured. So as I was saying, it's in the course of the trials which, of a number of individuals involved in the Peterloo meeting that this doctrine of unlawful assembly was elaborated and developed in the courts. The doctrine was to operate to allow government prosecutors to focus on the behavior, in particular whether violence was used of individuals and groups engaged in political protest, rather than solely the content of what was said in the course of protests. The targeting of which, as I said before, was becoming increasingly acceptable. So it allowed for this distraction to take place from what was being said, and rather the focus became on one's behavior. Rather than overtly clamping down on political activity, instead the government could focus primarily on the disorderly way in which an individual or group went about expressing political opinion, thereby diverting attention away from the political nature of the charge. Numbers became relevant. Large crowds were assumed to be violent and treacherous simply by virtue of the number of people present. After Peterloo, the Lord Chancellor told the Lords that, I quote, numbers constituted force, and force terror, and terror illegality. It is notable that those in government recognized that the greatest obstacle to prosecutions after Peterloo was the peaceful nature of the rally. Henry Hobhouse, permanent Under-Secretary of the State for the Home Department at the time of Peterloo, told the Halifax magistrate, Thomas Horton, that it is much easier to cope with the malcontents who do than with those who do not openly avow what their objects are. Lawyers, however, were on hand to help the state in articulating an offence which would capture the activity of the protesters. In the aftermath of Peterloo, they began to devise more specific notions of a law of unlawful assembly, which was to aid the government in dealing with those who participated in large rallies. Three main trials are important here, and I'm going to focus on that of R and Hunt. So in this case, R and Hunt, Justice Bailey held that while hearsay evidence of the slogans and banners which were held by those who gathered at St. Peter's Fields was admissible, evidence of the alleged attack of those assembled was not. Sir James Scarlett, Henry Hunt's prosecutor, quickly did away with the argument that those who had gathered at Peterloo had a right to free assembly, invoking the inherent danger and unpredictability of such a large gathering of people. The unlawfulness of the behavior of the defendants ultimately turned on the question of whether fear was caused to the public, and both defense and prosecution called witnesses and questioned them as to whether they had been afraid. While many witnesses for the prosecution denied being afraid, James Duncroft told the court that he did not think it safe to have that number of people on the streets of Manchester, particularly since they were, quote, persons belonging to the labouring classes. Ultimately, Justice Bailey held that the peaceful assembly at St. Peter's Fields was unlawful. The unlawfulness of the meeting stemmed from its being seditious and therefore created fear among the public. However, since it had not actually begun before it was attacked by the military and thus could not be shown to have caused fear, it was unlawful because the seditious words intended to have been spoken would have occasioned fear. So that sense of hypothetical situation was introduced into the law here. Crucially, it appeared as though Justice Bailey was cloaking a charge of seditious conspiracy, one not likely to result in conviction, in terms of the offence of unlawful assembly. With the passing of the Reform Act of 1832, which introduced constitutional change and a measure of political liberty, the expression of ideas alone could no longer be punished. The key element in proving unlawful assembly, therefore, became fear connected with physical force, or the threat of force. In spite of these developments, the offence has been taking shape in the courts for several years, and some judges continue to consider unlawful assembly applicable to peaceful situations. Lord Abinger, addressing the Lancaster Grand Jury of 1842, claimed that gatherings of several thousand could never be in a position to engage in serious discussion, and thus must lead, as everyone will see, to alarm and terror and to the disturbance of the peace. What is crucial to bring out in the analysis of the transition from the pre-liberal period to a liberal period, that is, the making of the security state compatible with liberal norms, is the depoliticizing significance of the charge of unlawful assembly as a means of dealing with political activists rather than high treason or sedition, which were overtly political charges. Through the use of public order offences, the state found a way of maintaining the distribution of power in society by criminalising unwanted political activity, but without appearing to be crushing political dissent. This elaboration of the use of public order offences against political activity paved the way for the case law of the 19th century, which developed the concepts of breach of the peace, obstruction, and nuisance, offences still used today. Thus, Richard Carlile, who had previously been prosecuted multiple times under seditious and blasphemous libel laws, found himself charged with nuisance in 1834 after he displayed blasphemous effigies in his Fleet Street shopfront. And Richard Carlile actually attended the St. Peter's Fields meetings, and he was due to speak that day too, but of course never had the opportunity, and he painted this painting afterwards. So his conviction of nuisance in 1834 after putting these effigies in his shopfront, it depended not on whether the effigies themselves were scandalous, but whether the crowds gathering on the pavements to survey them caused a nuisance. These offences continue to be used against protesters today, and a recent high-profile case in Britain saw Trenton Oldfield, who staged an anti-austerity, anti-elitism protest at the Oxford-Cambridge boat race of 2012, charged with public nuisance, found guilty and sentenced to 6 months in prison. Unlawful assembly was the forerunner to violent disorder, which is the statutory expression of the offence found in Section 2 of the Public Order Act of 1986. Violent disorder is the offence of choice for the police and Crown Prosecution Service when prosecuting protesters in Britain today. The offence, it's a serious offence with a maximum term of 5 years imprisonment. If found guilty, one's likely to go to prison. The assumption that crowds are inherent danger underlies public order offences currently in force. For the offences of riot, violent disorder, and affray in the Public Order Act, a certain number of individuals need to be present together, 12 for riot, 3 for violent disorder, 2 for affray, for the offence to be triggered. The hypothetical fear, which Hunt's conviction was based on, following Peterloo, plays a key role in the offence of violent disorder as it is expressed today. Section 2 of the Public Order Act provides that a person is guilty of violent disorder where 3 or more persons present together use or threaten violence that, would cause a person of reasonable firmness present at the scene to fear for his personal safety. However, no person of reasonable firmness need actually be or likely to be present at the scene. So that hypothetical element is very strongly written into the offence. Despite the offence being very similar to that of unlawful assembly, it's perhaps telling that the name of the offence was changed to violent disorder, reflecting the moral reprehensibility of the offender rather than the illiberalness of the state implied in unlawful assembly. Despite the evidence of indiscriminate baton use and heavy policing at public order events, order is habitually equated with the state and legitimacy, whilst the imaginary violence of the crowd tends to be conceived of as disordered and illegitimate. A number of protesters were charged with violent disorder relating to the student protests of 2010. These demonstrations, which took place in the autumn months of 2010, were organized in opposition to a hike in tuition fees and cuts to higher education funding more generally. In total, 58 protesters were charged with violent disorder, of whom 12 received prison sentences. However, of the 19 who pleaded not guilty, 18 were acquitted. In 2013, Alfie Meadows and Zach King succeeded in their plea of self-defense against charges of violent disorder relating to those protests of December 2010. It's clear that the trial judge, Justice Moore, was concerned at the shock and upset of the jury members at the evidence of the use of horse charges and indiscriminate baton use against young protesters subjected to containment or kettling on the day of the protest. Addressing the jury in the course of summing up, Justice Moore said, "It is imperative that you set political feelings or hostility or perhaps sympathy aside. It is not your job to assess the lawful nature of police action. In a case like this, it is very easy to be sidetracked into collateral issues. It is imperative that you look at evidence that is relevant to the issue to determine." The question of police violence is, however, far from being merely collateral to the question of violence on the part of protesters. The police are not neutral observers at demonstrations, but actively relate to those they are policing. If their tactics antagonize protesters, this ought to be borne in mind when any violence that may result is considered, not just in terms of considering a plea of self-defense, but more importantly, at the stage the decision to prosecute is being made. The Crown prosecution guidelines on when to prosecute protesters fail to account for the role played by police in creating the conditions for violence in their policing of public order events. According to the guidelines, certain factors make it more likely that prosecuting a protester will be considered to be in the public interest. The guidelines are intended to aid prosecutors when differentiating between violent or disruptive offenders and those whose intent was peaceful. Problematic is the underlying assumption that individuals attending protests necessarily have either peaceful or violent intentions. In fact, violence more frequently flows from police practices, including containment or kettling, the use of batons and dispersal techniques such as horse charges. Research on crowd behavior has shown that the behavior and presence of police at public order events affects to a significant extent the behavior of crowds they are policing. Indeed, heavy-handed policing has been shown to increase rather than decrease so-called disorder, as alienated individuals transform into collectives resisting and defending themselves against police violence. In his research on crowd behavior, Chris Cocking conducted a series of interviews with protesters subjected to police violence, to police tactics such as horse charges and baton use. And he concluded that police violence is a significant cause of violence on the part of protesters. One participant who attended an anti-tuition fees protest in 2010, when questioned about how she and the people around her reacted to a horse charge, gave the following response. "There was a sort of initial panic as people ran back. Fleeing would be the word I would describe it. There was a sort of shock that they would be charged like this, that you've got to run, turn and run, because if you don't run, you're going to get trampled by a horse or hit with a baton. And then very quickly, regroupment and a realization that what the police was doing was outrageous and there was no need to panic and actually you should turn around and have a go back." When asked what she remembered feeling after the horse charge and how the crowd behaved, she said, "It was like they were going back into battle. Before the charges, there was less togetherness, but the charges actually provoked people to come together and to go back as groups. Once the police attacked, the response was, 'We're going to go back in there.' And I saw kids pick up placard sticks. There was a real sense that we want to go back in there and have a fight." This insight into crowd behaviour contradicts the CPS guidelines on prosecuting protesters, which assume individuals come to protest with violent intentions. It also relates to a broader critique of the criminal law and its functioning to decontextualise the behaviour of individuals from the social context in which that behaviour takes place, treating the individual as a rational being with free will and thus wholly responsible for her actions. Evidence pertaining to the context in which actions take place, horse charges, baton use, kettling, ought, however, to be entirely relevant when assessing the morality of an individual's actions and when considering whether to charge a person with a serious offence. Such evidence should not merely attain relevance at the point at which the evidence in relation to self-defence is considered. The situation has not been helped by the European Court of Human Rights judgment in the 2011 case of Austin in UK that declared the kettling of protesters and passers-by at the 2001 May Day demonstrations did not deprive them of a right to liberty. The court accepted the UK government's argument that the containment needed to be prolonged due to the violent behaviour of a minority after the kettle's formation, but at no point did it consider that the coercion entailed in creating and maintaining the kettle might itself have caused the violence. The willingness of the courts to sanction coercive police tactics is especially worrying in light of the police and the CPS record of arresting and charging protesters with serious offences, in particular using the offence of violent disorder. In Austin, the court stated that circumstances necessitated the imposition of a cordon, despite the fact that the aim of the measure, which results in the restriction of liberty, cannot be taken into account when determining a breach, unless it falls under delimited subsections. The court also stated that kettling is one of those situations that, I quote, commonly occur in modern society where the public may be called on to endure restriction on freedom of movement or liberty in the interests of the common good. There is little sense in the entirety of the judgment that the kettled protesters were exercising their right to public protest, protected under Articles 10 and 11 of the Convention. There is not a modicum of evidence that the court entertained the thought that governments might perceive an interest in suppressing dissent and discouraging or deterring protest, and therefore the actions of their police forces should be subjected to an especially high level of scrutiny in the context of protest. Had the court considered this point, they may have avoided the wholly inappropriate analogies which they drew in comparing police actions at protest to the policing of traffic incidents. In this talk, I have attempted to draw out the continuity in the development of public order offences, showing how the elements of the law on unlawful assembly, elaborated following the Peterloo trials in the early 1800s, have to a significant extent been retained in existing legal provisions on public order used against protesters today. In the operation of public order offences, there is an identifiable tradition of evidence of violent police tactics being deemed inadmissible, even though they are material to both understanding the behaviour of protesters in response to tactics such as baton use, horse charges and kettling. We saw this in the exclusion of evidence in the attack on the 1819 Peterloo rally, in the case of Aaron Hunt, as well as in the cases of Austin, UK and Aaron Meadows. The significance of the depoliticising effect of public order legislation is multifaceted, but I suppose the thing that I would want to draw out in closing is the way in which it contributes to the tendency to conceptualise state institutions such as the police as neutral and rational structures, and crowds or citizens as collectives, as amorphous mobs behaving in irrational and partisan ways. Since I carried out this research, the British state has continued to use the offence of violent disorder against protesters. It's important to note the political context in Britain following the European Union referendum, which has had the effect of licensing the expression of racism and xenophobia with deadly consequences. We've already had the murder of a left-wing MP, Joe Cox, 1 week prior to the vote, and a young Polish man, Arek Jozwiak, since the referendum. There has been a 14% rise in reported hate crimes across the UK since the vote to leave the European Union. There is another significant genealogical connection to be drawn here, one that I have written about elsewhere but will briefly mention. The racist discourse of taking back control that defined the Brexit campaign must be understood in the context of Britain's imperial legacy. In the days of empire, Britain defined its racial and cultural superiority, exploiting and subjugating peoples on the basis of race, a system that was maintained through the brutal and systematic violence of the colonial authorities, a system which has left Britain with a legacy of deeply entrenched structural racism. Today in Britain, marginalised and racialised groups are the targets of street attacks and state violence such as police brutality and deportation. Mirroring its response to the student protesters in 2010, the state has used serious criminal charges against those who have sought to defend racialized people victimized by the state. Recently, 3 young men, known as the East Street Three, were charged with violent disorder following a peaceful protest in London, in the course of an immigration raid, these protesters gathered to stop the van with an individual inside from being deported. The men were arrested and charged after this crowd of local residents gathered around the immigration enforcement vehicle, and the man has since been detained and deported. The crowd were attacked by police in riot gear, and a number of protesters were injured by the police and police dogs. 2 of the men were recently acquitted by a jury last month, but in the case of the third, the only black defendant, it was a hung jury. The violence of the court process will have lasting effects on their and their families' lives, and indeed we don't yet know what will happen to this one protester who was likely to be tried again. And it raises, of course, serious concerns about the shrinking spaces for urgently needed political resistance in Britain today. Thank you.